Next up, we want to talk about power of attorney and medical directives. Of course, top of mind for a lot of people as they're heading into retirement, Charlie.
Absolutely. Incredibly critical documents as part of your estate plan. They come in multiple varieties, but really we're talking about a medical power of attorney, which for most of us in Iowa is going to include what we call a living will or advanced directives. And then we're talking about a financial power of attorney. I think most people can tell the difference. Medical power of attorney is about medical decisions. Who's going to step in? Who's going to make those medical decisions for you if you can't make your own? Living will is, in essence, stating if you're on a ventilator, you're on a feeding tube, you have no brain activity, and the physician is fairly certain you're not going to, more than fairly certain, I would hope, very certain that you're not going to recover, allow you to go naturally. But what a lot of people don't know about medical power of attorney, it also lets you move medical records from point A to point B. And there's a couple of choices you have to make about being left on a ventilator as part of organ donation, and also who can move medical records and what access or not access do they have. So again, incredibly critical documents. Financial power of attorney is probably even more critical. The reason why is there are some default provisions for healthcare power of attorney in our state. There are not for financial power of attorney. So on a financial power of attorney, you get to pick who's going to make financial decisions for you if you can't make your own. The scenario is generally you're alive, but you're incapacitated, whether that's mentally or physically, and you can't handle those decisions. You get to pick what decisions they have control over, and just as importantly, when they get to make those decisions. Is this document live the second we sign it? Or do we need a doctor's note that says, yes, you need to invoke the power of attorney? So again, any estate planning package or any estate planning setup that you have critically needs medical and financial powers of attorney. I dealt with a situation a while ago, business owner, he was the only one on the business, no financial power of attorney, he had a stroke, couldn't make payroll because he was the only one who was authorized to do payroll. A little bit of really, really basic front-end planning could have made his wife, who also worked in the business, the vice president of the company or his financial power of attorney or something that would have been able to handle that. So needless to say, if we need to seek guardianship and conservatorship, which are the court versions of financial power of attorney and medical power of attorney, it's a heck of a lot more expensive. It's a heck of a lot more traumatizing on everybody to have to go through that process. It's easier just to pre-plan a little bit.
And do you find that it's difficult for people to decide who to name the power of attorney and medical power of attorney?
It really depends. And oftentimes what I will do is I will break them apart into two very, very separate conversations. And I say, if you were in a car crash and you couldn't make your own decisions, other than your spouse, which is where most people start, but maybe you're not married, or maybe it's a second marriage and you have adult kids, that's always a fun one. Who would you want making those medical decisions for you? And oftentimes the client has somebody in their family who's in healthcare, but oftentimes the client also has somebody in their family who really struggles with emotional decisions. And it's maybe not as much of a we're picking this person as maybe we're putting this person, out of a spot that they're not going to be able to handle. Financial is the other way. Maybe they're that same person who's emotional and can't handle those decisions is great with finances and is very organized and can handle all of that. So it's really important to have those conversations because a lot of people, and I fully support this as a firstborn child, a lot of people just pick their oldest kid. Well, maybe that's not the right choice. Maybe it is, but the key is we got to make sure the plan fits the clients and it fits really who those personalities are.
And then once they make their selection on who they're going to have as their power of attorney, do you find that it's good for them to communicate to that individual or individuals, hey, here's what I decided and this is what that means to you? Absolutely.
Because here's the deal. Loren, if I'm your financial power of attorney and I'm your medical power of attorney and you're in a car crash and I don't know, makes it kind of hard for me to know I got to go do that job. Right? And if I don't have the document, right? That's the second question that you didn't ask. Do they need a document? Maybe, maybe not. They at least need to know where to get it, whether that's in your office, whether that's your attorney's card so they can contact you. But that's great. If I'm power of attorney and I don't have the physical document, guess what? I'm not power of attorney because the hospital's not just going to take my word for it. The bank is sure not just going to take my word for it.
Yeah, so you'd recommend the power of attorney also have that physical document. Does it need to be an official notarized document, or can it be a copy of the official document?
So the original document will be notarized, right? A scan or a copy is normally good enough in most situations. There are some spots where you need an original financial power of attorney, but they're usually pretty few and far between unless we're dealing with real estate. So whether it's get them a copy or at least let them know where they can get a copy, one of those two things is critical.